I'm Ben Meiselas from the MeidasTouch Network. Special Counsel Jack Smith is moving at lightning pace, just filing in the criminal docket in the case against Donald Trump, the government's response to the standing discovery order, whereby Special Counsel Jack Smith confirms to the federal court that all non-classified information has essentially already been turned over to Donald Trump, and this includes grand jury testimony, including those of witnesses who intend to testify against Donald Trump, audio recordings of Donald Trump, the testimony that was previously given by Donald Trump's co-defendant, Walt Nauta. Special Counsel Jack Smith is basically calling the bluff of anybody trying to cause delay here and basically saying, here, right away, you have all of the records, all of the documents, any document that could be described as exculpatory, any document that could be described as inculpatory, all of the relevant documents necessary to prepare a defense, all of the documents we, the prosecution, intend to rely on at the time of trial. Donald Trump and Donald Trump's lawyers now have it, pursuant to the protective order, the motion of which was filed just this week and granted by Bruce Reinhart, the magistrate judge. So as soon as that protective order was entered, boom, immediately Special Counsel Jack Smith turned over all the non-classified records to say, let's get the show on the road. And so let's take a look at this filing by Special Counsel Jack Smith and let's analyze it. It's called Government's Response to the Standing Discovery Order. And this just basically means in courts there's a standing order regarding the types of documents that the government is required to turn over in any case. But here Special Counsel Jack Smith was over-inclusive and just said, here, take everything. We're ready to go to trial. And here's what Special Counsel Jack Smith's motion says the following. The United States of America, by and through the Special Counsel's office, in response to the standing discovery order issued in this case, files this response. This response also complies with the local rules and Federal Rule of Criminal Procedure 16. On June 21, 2023, per the protective order issued in this case, the government provided to defendant Donald J. Trump its first production of unclassified discovery, Production 1. The production was made available in 3 parts. The first part includes, inter alia, Latin just means among other things, documents obtained via subpoena, evidence obtained via search warrants, transcripts of grand jury testimony taken before a grand jury in the District of Columbia, and transcripts of grand jury testimony taken before a grand jury in the Southern District of Florida, and memorialization of witness interviews conducted through May 12, 2023. As we have informed counsel, it is the government's intent to disclose promptly all witness statements and associated memorialization of those statements, even if they would not be deemed discoverable under 18 U.S.C. Section 3500. In other words, even if we, the Department of Justice, have no legal obligation to turn it over, we're just going to give Donald Trump everything that we have through his lawyers under the protective order so that there could be no disputes here because we are ready to go to trial. The filing goes on to say, the second part includes a reproduction of key documents and photographs included in Production 1 that are referenced in the indictment and others determined by the government to be pertinent to the case. The third part consists of complete copies of closed-circuit television CCTV footage obtained by the government in its investigation. To facilitate review, the government also identified and separately produced for the defense, quote, key excerpts from the CCTV footage, including excerpts referenced in the indictment or otherwise determined by the government to be pertinent to the case. The government responds to these specific items identified in the standard discovery order as set forth below. So what the government is saying, not only did we turn over all of the CCTV surveillance footage that we got via subpoena, we are making it even easier for Donald Trump and his lawyers here. So there's no fights, there's no discovery issues, there's no trying to delay it. We've made a key for them. We've dummy-proofed this, and we've showed them where the key moments are. By the way, they can go through it for themselves, so they have all the footage, but we're showing them what the key portions are that we intend to rely on at trial. And why is Special Counsel Jack Smith doing this? Because the moment Donald Trump and his lawyers try to whine for a continuance and delay to Judge Eileen Cannon, Special Counsel Jack Smith wants to say, we did all this work for them. We literally made a key for them of the key moments. We did the work for them. But this also shows you how prepared Special Counsel Jack Smith is. So these are the specific items as well in the standing order of the court that's called for in criminal cases. And this is how Special Counsel Jack Smith responds to it. A1, Production 1 includes a copy of any written or recorded statements made by the defendants. These statements include the following: interviews of defendant Trump conducted by non-government entities which were recorded with his consent and obtained by the special counsel's office during the investigation of this case, including the July 21, 2021 recorded interview defendant Trump provided to a publisher and writer quoted in the indictment. Public statements made by defendant Trump, including the public statements quoted in the indictment. By the way, it's not limited to, so Lordy, there are other tapes, and I assume what these public statements are, all of these videos we talk about here on the MeidasTouch network when we say Special Counsel Jack Smith is going to be using this as evidence. Special Counsel Jack Smith's undoubtedly turning over all of Donald Trump's social media posts, all of Donald Trump's statements that he made to Bret Baier and in his other interviews and at his fascist rallies, so on and so forth. Also, as part of this discovery, it includes the May 26, 2022 FBI interview of defendant Nauta, which is quoted in the indictment. Also, the June 21, 2022 grand jury testimony of co-defendant Waltine Nauta. 2. Other than the two statements of defendant Nauta identified in paragraph A1, there are no relevant oral statements made by either defendant before or after arrest in response to interrogation by any person then known to the defendant to be a government agent that the government intends to use at trial. 3. Defendant Trump has not testified before a grand jury. On June 21, 2022, defendant Nauta testified before a grand jury. Here are those transcripts. 4. The government provided defendant Trump and defendant Nauta's team NCIC records. Those are just National Crime Information Center records, just a standard disclosure. Defense counsel can contact the government to arrange for inspection of unclassified items seized at Mar-a-Lago on August 8, 2022. The government is not currently aware of any other unclassified books, papers, documents, data, photographs, tangible objects, buildings, or places within the government's possession, custody, or control, which are material to the preparation of the defense. There were no physical or mental examinations of defendants. B is just the demand for reciprocal discovery, where the United States requests documents from Donald Trump. There was a footnote in the page or two before just pointing out that Waltine Nauta has not been arraigned yet, and when Waltine Nauta is arraigned, these will be turned over to him as well. The government has turned over information and material that could be favorable to either defendant, known as Brady material. The government will disclose any payments, promises of immunity, leniences, or preferential treatment or other inducements made to prospective government witnesses. The government will disclose any prior convictions of any alleged co-conspirator, accomplice, or informant who will testify for the government at trial. The defendants were not identified in any sort of traditional lineup. The government has advised its agents and officers involved in this case to preserve all rough notes. The government will timely advise defendants of its intents, if any, to introduce at trial extrinsic act evidence pursuant to the federal rules. The defendants are not aggrieved persons. J, Production 1. This is big. Production 1 includes the grand jury testimony of witnesses who will testify for the government at the trial of this case. So as of right now, while you're watching this, Donald Trump now has a list of witnesses people ready to testify against him at the time of trial. And then some of these other disclosures just talk about things that are not related to this case. Goes on to say the government is aware that it has a continuing duty to disclose newly discovered additional information required by the standing order and the relevant case law and precedent, in addition to the requests made above by the government pursuant to both Section B of the Standing Discovery Order and Rule 16B in accordance with Rule 12.1 of the Federal Rules of Criminal Procedure. The government hereby demands notice of alibi defense. The approximate time, date, and place of the offense is set forth in the indictment, signed by Special Counsel Jack Smith and his lead prosecutor in this case, Jay Bratt, who heads the counterintelligence department at the Department of Justice. And there you have it, folks. Big move in this case. Special Counsel Jack Smith telling the court, we're ready to go. Not only have we turned over what we were obligated to, we went above and beyond and dummy-proofed this for Donald Trump and his lawyers so they could be saying no delays here, that they don't have the information. Let's go. That's what you have. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers. Thanks to your incredible support. Check us out at patreon.com/MeidasTouch. And wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Thank you for watching, and hit subscribe on the YouTube channel. Have a great day.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.